Good morning, everyone. Thank you for joining our media call this morning to discuss the federal court's ruling last week that Georgia's state legislative district maps dilute the voting strength of Black voters and must be withdrawn. We will talk about that ruling from last week and discuss the impact on Black voters. At the start, you will hear from our speakers this morning, and our speakers are Andrea Young, who is Executive Director of the ACLU of Georgia, Rahul Garabadu, who is our Senior Voting Rights Attorney, Ari Savitsky, who is Senior Staff Attorney at ACLU Nationwide's Voting Rights Project, Bishop Reginald T. Jackson, who is Bishop of the 6th District of the African American Methodist Episcopal Church. You will also hear from George Varghese, who is a partner at WilmerHale. You will hear from the speakers. After each of the speakers, we will take questions. I will, for the questions, raise your hands. I will recognize you and you can introduce yourself, ask your question, and we will wrap up at the top of the hour. So now I'll kick it over to Andrea, who will get us started. Thank you.
Thank you all so much for being here, and to our panelists who are all very busy people in their lives. Last week, when this was decided, it was a very, very busy news week, as every week seems to be these days. And, we wanted to really root this discussion in the struggle of Black Georgians for full representation, right? So this case is rooted in more than a century of struggle of Black voters and Black Georgians to have full representation in their government. When the Voting Rights Act was signed, this was a case brought under the Voting Rights Act, there was only one Black person in the Georgia General Assembly, Leroy Johnson, although Georgia's Black population was around 28%. It had been 50 years between Leroy Johnson and the last Black member of the Georgia General Assembly. It was 100 years between Jefferson Franklin Long's representation in Congress in the Reconstruction era and my dad, Andrew Young's election in 1972, an election that also required intervention by the ACLU in Georgia's redistricting maps. So we want to focus this briefing on the long denied aspirations of Black Georgians to be full citizens of Georgia, to be fully represented where the state where, for many of us, our ancestors were enslaved, where we suffered under Jim Crow laws, where we now pay taxes, build the economy, and the culture. We'll have presentations, and then we will really want your questions. We really want an opportunity for discussion. So I'll turn this over now to Rahul Garabadu, our senior staff attorney, who, like me, is a native-born Georgian, to talk about the case. Rahul?
Good morning, everyone, and thanks for attending this morning to talk about this decision. My name is Rahul Garabadu, and I work for the ACLU of Georgia. I'm proud to be one of the many attorneys who litigated the Alpha Phi Alpha case, along with my colleagues from the ACLU Voting Rights Project and the law firm of WilmerHale. As many of y'all know, our fight for fair maps this cycle didn't just begin with our lawsuit. Months before the 2021 special session began, the ACLU of Georgia and its partners testified in redistricting town halls held across the state. We wanted to make sure that legislators were educated about what preliminary census data was already showing us, that Georgia had experienced a seismic demographic shift over the past decade. The final census data numbers would later confirm that Georgia added nearly 1 million people to its population over the last decade, nearly half of whom were Black. That translated to about a 16% jump in Black population, while white population actually declined in Georgia. So in other words, all of Georgia's population growth in the last decade was attributable to people of color. After the final census numbers came in, we continued our efforts to educate legislators and the public about the changing face of Georgia. We were invited to testify at a joint meeting of the Senate and House redistricting committees to provide testimony about what a fair map drawing process would look like, what the law required, and how the General Assembly should ensure transparency and fairness in the process. We continued these efforts through the special session that happened in October of 2021, warning legislators that not accounting for demographic changes in Georgia could expose the state to legal liability. So when the state ended up passing state House and state Senate maps in December of 2021 that failed to properly account for Georgia's tremendous diversification, we were ready to act. We partnered with organizations like the 6th District of the African Methodist Episcopal Church, one of the nation's oldest Black churches, and you'll hear from Bishop Jackson in a few minutes, as well as Alpha Phi Alpha Fraternity, the nation's oldest Black fraternity, and individual voters across the state of Georgia. Minutes after the maps were signed into law by the governor in December of 2021, we filed a lawsuit on behalf of these groups of voters alleging that Georgia could have, and more importantly, should have drawn additional Black majority state House and state Senate districts. Now, not drawing those additional Black majority districts diluted the power of Black voting strength, and it violated Section 2 of the Voting Rights Act. I'm now going to pass it over to George Varghese at WilmerHale to talk a little bit about what our efforts in court have looked like over the past couple of years. George?
Thanks, Rahul. And good morning, everyone. Thank you for joining us. First, let me say on behalf of WilmerHale, we were thrilled with the verdict that came out from Judge Jones. This has been a tremendous victory, but it's also a victory that is long time coming. As Rahul mentioned, this case started in December of 2021. We moved very quickly to file a lawsuit after we saw what the maps were going to look like. And shortly thereafter, in February of 2022, we asked for a preliminary injunction hearing. And the court held a 6-day preliminary injunction hearing in Atlanta before Judge Jones. And we there was testimony from 14 live witnesses who talked about the maps and talked about how they would in fact be diluting the strength of Black voters in Georgia. It was actually a very successful hearing, and the court made factual findings in our favor and found that there was a substantial likelihood that we were going to succeed on the merits. But ultimately, Judge Jones denied the preliminary injunction at that stage. And the reason why was that he felt that it was too close to the next election to redraw the maps without risking voter confusion, something in the law that's known as the Purcell principle. And he felt like we were too close to the next election to install new maps. We understood the judge's findings, but we were buoyed by the fact that he did agree that we were likely to succeed on the merits. So fast forward to September of 2023. This past summer, as many of you know, the Supreme Court reaffirmed the Voting Rights Act in Section 2 in the Milligan case. And so we felt good going into the trial that we had a strong case, that we had a judge who understood the facts, and we had facts that showed that the legislature had purposely been diminishing the voting strength of Black voters by redrawing these maps. In September of 2023, the court held an 8-day trial. It was actually coordinated with 2 other Section 2 cases challenging Georgia's state and congressional maps as well. During that trial, the court heard testimony from 20 witnesses and accepted testimony from 22 additional witnesses via depositions. And then, as you all know, on October 26th, Judge Jones issued his decision. It's a long one, 516 pages. The ruling was very careful and unequivocal that the state's maps, as drawn by the legislature, violate the Voting Rights Act and must be redrawn by December 8th. Judge Jones was confident that that gives the legislature enough time to redraw the maps that are compliant with the Voting Rights Act, and he made clear that if they did not, he would act. And there's plenty of time for these maps to be newly drawn in time for the elections. We feel very proud of the work that we did alongside the ACLU of Georgia, alongside with the ACLU National Voting Rights Project, and on behalf of our plaintiffs and our clients. It was a tremendous victory, not only for our plaintiff clients, but also for all Black voters in Georgia. And with that, let me turn it over to Ari Savitsky of the ACLU Voting Rights Project. Ari?
Thanks so much, George. I'm Ari Savitsky. I'm an attorney with the National ACLU's Voting Rights Project. I'll echo first what George and others have said. As part of the legal team that tried this case, I want to first say what an honor it was and remains to represent Alpha Phi Alpha, AME Church, our individual clients, to stand up for the rights of Black Georgians to fair legislative districts, and to work with such a fantastic group of attorneys and advocates from ACLU of Georgia and WilmerHale. And I will also echo what Andrea and others have said. We are thrilled that the trial court, after hearing all the evidence over the course of that 2-week trial, with so many witnesses and so much detail, has issued this decision, which requires the state of Georgia to draw 2 additional Black majority Senate districts and 5 additional Black majority House districts. This is a huge win for Black voters in Georgia and for all Georgians who want a level political playing field and progress from the past. This court's decision, as George mentioned, is extremely detailed, over 500 pages long. The question I'll address: what does the court's order do? What happens next? Taking into account our claims and another set of claims brought by a parallel group of plaintiffs, the court issued an order, bottom line, holding legislative maps, the maps that were enacted by the state in December 2021 that we went to court to challenge immediately, are unlawful. They cannot be used in any more elections. The state of Georgia must now draw 2 additional Black majority Senate districts in the South Metro Atlanta area, an area where the evidence showed Black voters, where Black voters must have a fair opportunity to elect candidates of choice. And based on the evidence presented at trial, this area, including places like Fayette County, Rockdale County, Henry County, Spalding County, Newton County, and surrounding areas. These are areas where the evidence showed there have been truly massive levels of Black population growth and change, and yet there was no increase in the number of Black majority districts. And so now 2 additional Black majority Senate districts must be drawn in those parts of Metro Atlanta. The order also requires the state of Georgia to draw 5 additional Black majority House districts, in which Black voters will have a fair opportunity to elect candidates of choice. 2 of those are in that same area of Metro Atlanta. One would be in another portion of Metro Atlanta, in the Western Metro area. And 2 need to be drawn in the Macon Metro area, including the area extending east towards Milledgeville. And again, the demographic evidence shows that you've seen Black population growth and population change in those areas without an increase in the number of Black majority districts or districts where Black voters have a fair opportunity to elect candidates of their choice. The next step is the General Assembly will have an opportunity to revise the maps to create these new opportunities for Black voters and comply with the Voting Rights Act, consistent with the demographic realities shown by the 2020 census. And so we would acknowledge and we're heartened by the fact that Governor Kemp has already called a special session into place for the end of this month. The remedial process with the court always remains a backstop, no matter what happens. And so we are very heartened, as George said, that the court's order makes clear new maps that comply with the Voting Rights Act must be in place in time for the 2024 election, so that in 2024 and beyond, voters are able to vote with legislative maps that fairly represent all Georgians and comply with Section 2 of the Voting Rights Act. As the court made clear, another election cannot and must not take place using maps that have now been determined to be unlawful and contrary to the Voting Rights Act. So I will now pass it to Bishop Jackson from the AME Church, who again, I'm very honored to be here with today and to represent in this case.
Good morning. I'm Bishop Reginald Jackson, Bishop of the 6th Episcopal District of the African Methodist Episcopal Church, which represents about 500 churches across the state of Georgia. The decision by Judge Jones is a victory for Blacks in the state of Georgia, and even more for the state of Georgia itself. It is important to note that the drawing of these districts were intentional. It was a deliberate effort to ignore and make the effort of Blacks to increase their participation in the political process more difficult. It was an effort to ignore and make insignificant almost 500,000 Black citizens. The Republican Party of Georgia, since the very close election of 2018, has done everything it could except pass a law making Black voting illegal to dilute or ignore the rising tide of Black voters. The decision by Judge Jones now provides the opportunity for the votes of Blacks to count, and more importantly, to demonstrate that Black voters do matter. The AME Church, which has a legacy of fighting for voting rights and social justice, will join with other faith leaders across the state and other organizations, such as the ACLU and others, to ensure that Blacks not only have the right to vote, but that they actually vote. And it's also our responsibility to make sure that this session of the General Assembly, which the governor has called for November the 29th, follows Judge Jones' directive, that in fact we do provide those districts which will enhance Black political participation in the life of Georgia and provide representation for all of the citizens of Georgia. So while the decision has been made by Judge Jones, now even more important is going to be the decision by the Georgia legislature to make sure that what is produced is what was directed by Judge Jones. So we look forward to the days ahead. We understand that the challenge is over, and we're going to do all that we can to make sure that the case of Alpha Phi Alpha fraternity versus Raffensperger turns out to be in the best interest of the state of Georgia, and particularly the rising tide of Black voters all across this state.
Thank you, everyone. So now we will take your questions. If you have a question, please raise your hand and I will call on you. Okay, Chauncey, I see your hand is raised. You can go ahead.
Unmute. Can you guys hear me now?
Yes.
Okay. Bishop Jackson, thanks for joining us and for taking my question. So I'm curious, first and foremost, we talked a little, some of the attorneys touched on this earlier, but why did you specifically in the AME Church decide that to be plaintiffs in this case and to represent the interests of folks in the 6th district specifically, but Black people across the state in particular?
There were a number of reasons. First of all, because the AME Church itself has a legacy of social justice. It has a history of fighting for voting rights. So that was the first reason. The second reason was there were members of our denomination here in the state who contacted my office because they had difficulties in voting. And upon following up on several things, we found out this was a problem across the state. Third thing was, though, all of us could see that the population of Blacks in this state had increased. But at the same time, while the population has increased, our representation in the state legislature had not increased. And in fact, we saw where Black populations were juggled around like a chessboard so that we would be lumped together and we would dilute the possibility of increased participation. And the final reason for me was personal. I was assigned to Georgia in 2016, and I was absolutely distressed to see how low the Black turnout was in the 2016 election. And I said to Blacks across the state of Georgia that I was angry, and that what happened in the 2016 election will not happen in the forthcoming elections. And I'm pleased that we have at least made sure that doesn't happen again.
Jill, you can ask your question.
Hi, can you hear me?
Yes.
I can hear you.
Okay, thank you. Thank you all for doing this. Wanted to ask about a likely appeal of the court's decision. The state has said, it was reported yesterday, the state does not plan to request this stay, but they do intend to appeal. Meanwhile, the governor's already, as y'all have noted, called for the special session. So I'm just kind of curious from your point of view, how you see those things playing out and how a likely appeal might affect the special session.
Well, let me say it's you know, what the Republicans do is their decision to make. I would hope that they've learned from what happened with Alabama, that they simply need to go ahead and draw the districts according to Judge Jones' decision. And then we can move on to make sure that we have fair elections where everybody has the opportunity to vote. So if they decide to appeal, it's our expectation that the result will come out the same as it did in Alabama.
Yeah, and just to add on to that a little bit, you know, I think we're glad that the state is not trying to press pause on this decision. And as Ari and George have noted already, the judge's decision in this case was over 500 pages long, which reflects the amount of evidence and testimony that we put forward to substantiate our claims. So I think we're confident that this ruling will be upheld in the appeals process and that Georgians will have new maps in time for the 2024 election cycle.
Jeff, do you have a question?
Yes, can you hear me?
Yes.
Do the plaintiffs believe that it would meet the terms of Judge Jones's ruling if lawmakers dismembered the current 7th congressional district to create a new majority Black district somewhere else?
I hate to be talking so much, but let me say that's a sensitive issue. I live in the 6th district, and that district was one of those which they jockeyed with. They were drawing the maps so that we have a new congressperson because they juggled around the population. And it's important to note that the population of the 6th district before they changed the maps was almost exactly to the person the number of people you needed for a congressional district. So there was no need for them to juggle the district at all, which means they intentionally juggled the district to change how the representation would be and to delete a Black representative in Congress. So it does matter, and I sure hope we do, in fact, accommodate the change.
Okay, and I appreciate those comments, but I was asking about the 7th district in Gwinnett County and not the 6th district.
So I can try to respond to the question briefly. First of all, just as a point of clarification, the case that we brought was really focused on state legislative districts. So as George mentioned, there were several different parallel cases. One of them involved the congressional map. So I do want to make that clear. As a general matter, and in terms of how we believe the state should respond to the court's order, it is not acceptable to sort of rob Peter to pay Paul, so to speak, to draw a black majority district in one new place and take away a black majority district that's effective for black voters in another place. The court's order calls for an additional, multiple in the case of the Senate, and 5 in the case of the House, additional effective black majority districts. And so to sort of change the pieces around so that there are districts in some places, but now there aren't districts that used to be there that were effective for black voters in other places, that would not comply with the terms of the court's order.
Sam, I see that you also had a question about the 7th district. Did you, was that question answered for you? If not, please ask other questions you have.
I guess my follow-up question would be, are there any protections under the law for districts that aren't expressly majority black districts like CD7, but people of color comprise a majority of the district? Would the Republicans just be leaning on the instructions or the warning from Judge Jones not to dismember that district, or are there explicit protections in the VRA or elsewhere for a district like that one?
I'm happy to take a crack at that one as well. I would first of all say, I mean, the case that we brought was specifically about the rights of black voters and drawing additional black majority districts. It is certainly possible to bring a Voting Rights Act claim involving other racial minority groups. There are also limitations, constitutional limitations on the way that considerations of race can be used or misused in drawing districts in order to come up with a particular political result. And so the requirements of the Voting Rights Act and the requirements of the Constitution always apply whenever legislatures engage in districting, and they will apply in the special session as well. And no doubt numerous groups will be looking very closely at what happens in the special session to ensure that all the requirements of the law, including the Voting Rights Act and the Constitution, are followed as the legislature revises the maps to comply with the court's order.
Jeff, do you have another question?
Yes. How long is an 11th Circuit appeal likely to take if it moves quickly? And is it possible that we're going to draw new districts that are used in the 2024 election, and then the state's going to win its appeal, and we're going to go back to the districts that exist now in 2026?
I'll take a crack at that one. So in terms of the 11th Circuit, a lot of it depends on how the court wants to handle it. I think it's really telling that the state elected not to seek a stay here. I think it sort of represents the strength of their recognition of the strength of their potential appeal. They did not seek a stay, which means that these new maps will be used for the 2024 election. What that also means is that the 11th Circuit will not necessarily feel like they need to expedite the appeal or hear it on a quick basis. They might handle it just like they would any other normal appeal, which will take time. Not only time for briefing, but then for oral arguments, and then time for them to write a decision. What we know about the state and their positions is that they're likely just to rehash the same arguments they made before Judge Jones. And if they do that, it's unlikely that they'll prevail in the 11th Circuit. But it's going to take some time to play out. And Jeff, to your point of, well, does that mean that they could win and therefore we'd be back to the old districts? It's possible, but we don't think it's likely, given the fact that Judge Jones had a meticulously written 516-page opinion that was very well reasoned and based on a lot of factual findings. We don't think the state will be able to prevail on the 11th Circuit. We think instead that really what they're trying to do is to challenge the constitutionality of the Voting Rights Act in its entirety. And we saw that during the course of this litigation. And the Supreme Court upheld the Section 2 of the Voting Rights Act. And we feel confident that if it goes that far, they'll do it again.
Jeff, I see you have another question. I'm going to come back to you. I want to give Jasmine an opportunity to ask her question.
Hello, good morning. Similar to the very first question, can anyone speak about the value of having Alpha Phi Alpha as a plaintiff in this case?
Since we don't have a representative from Alpha Phi Alpha here with us today, unfortunately, because of scheduling issues, I'm happy to speak on behalf of our clients. Alpha Phi Alpha fraternity, like I mentioned, is the nation's oldest Black fraternity. And in the Georgia district, Alpha Phi Alpha has thousands of members across the state, mainly Black male members. So they wanted to participate in this litigation to vindicate, again, the rights of Black voters. And similar to the 6th District of the AME Church, Alpha Phi Alpha has been involved in voting-related programs throughout its history. Since the 1930s, Alpha Phi Alpha has had a program called "A Voteless People is a Voteless People is a Hopeless People," which has sought to vindicate the right to vote here in Georgia and across the nation. So we were, again, very honored to represent an organization like Alpha Phi Alpha, like the 6th District of the AME Church, who has really been fighting for the rights of Black voters and all voters across the state of Georgia.
Jeff, you have another question?
Do you believe that it is possible to create 2 additional Black majority House districts in and around Macon without eliminating 2 current white majority districts that are held by Republicans?
I mean, I don't know if I can give a definitive answer to that question. In part because the question of what's possible is one that under the law first goes to the General Assembly. The order requires the creation of 2 additional Black majority districts, and as mentioned earlier, that is in addition to districts already existing where Black voters have an opportunity to elect candidates of choice. So whether those would, the party affiliation or the race of the incumbent of districts that would be affected, I can't say definitively for sure. They could well be districts where there's currently a white Republican in office, but that would sort of be for the legislature, for the General Assembly, I should say, to determine. The one other thing I would add, just as a point of clarification, is in terms of the evidence that was presented, these are districts that I think could extend outside of the Macon, the 5-county Macon-Bibb, metro area. As mentioned, some of the illustrative districts that were presented, went all the way to Milledgeville, Baldwin County. So I think in terms of what the court's order points to it's a somewhat larger geographic area. But again, ultimately, the point is that the court's issued an order, and now the General Assembly will have to do all that sort of weighing of the different districting factors, and come up with a new map that satisfies the court's order and that complies with the VRA, the Constitution, and the law.
Chauncey, I see you have, do you have another question?
I do. Bishop Jackson, this one's for you as well. We know that your organization, FaithWorks, is nonpartisan, I believe, and Black people in Georgia and across the country are not a monolith, but 90% of them roughly vote Democrat. They make up more than half of the registered voters in the Democratic Party. I spoke recently with Representative Carl Gilliard, head of the Georgia Legislative Black Caucus, about what the what can it be expected as a result of this judicial ruling. And he talked about the roughly 12 or 13 seat difference between the Republican majority in that state house and the Democratic caucus, and that this, five seats, assuming that they're all, if they're Black folks that vote Democrats, and that is an assumption, it wouldn't necessarily shift the balance of power in the Georgia General Assembly. So my question is for Black people in particular, and who will be reading this, who are saying, okay, how is this going to actually change my life or impact my life? Could you talk a little bit about what the actual tangible benefits of this are in terms of their increased voting power, how this might affect policy, how it might affect electoral politics in the state of Georgia, and particularly in these areas where they will have new districts drawn?
Bishop Jackson, you're muted.
I'm sorry. I'm a firm believer that everything rises and falls on leadership, and that leadership is influence. And I am thoroughly convinced that more Blacks who are elected in the state legislature will, in fact, increase their influence. And I also believe that the more Georgia's population shifts, I believe you're going to be able to see a shift in some attitudes and some positions on issues. And so I don't expect this decision to make a sudden change overnight, but I do think that this decision points to that which is inevitable, that the more the population increases, the more representation in the legislature will increase. The more representation in the legislature increases, the more policies will change. So this is an ongoing process, and I think we will begin to see some changes taking place in the attitude of the legislature and in the makeup of the legislature.
Do we have any more questions? Not seeing any more questions, I want to thank everyone for their time this morning, and also everyone who is here and has registered will receive via email a recording of this call. And if you have additional questions, you can reach out to the media contacts on the media advisory that was sent for this call. Once again, thank you, everyone. Have a great day.
Thank you.